From the October 26th presidential election. Well, interpretations from both sides of the political divide are leaving Kenyans none the wiser. NASA arguing it means the IEBC should cancel the election and conduct fresh nominations, and Jubilee arguing the elections will go on despite Odinga's withdrawal. Right now, on the big question, we have MP or woman rep, who's Gladys Sholei, Uasin Gishu woman rep, also a lawyer. In studio also, Charles Nyachai, former CIC chair, who also vied for the Kisii Senate seat on a Jubilee Party ticket, also a lawyer. Willis Otieno is the head of Raila Odinga Presidential Secretariat, also a lawyer. And Edwin Sifuna, who also vied for the Nairobi Senate seat on an ODM ticket, again, a lawyer. Well, thank you so much for making time for us all tonight. We're asking you tonight, what do you make of Odinga's withdrawal from the October 26th election? Talk to us. The hashtag is a big question on Twitter. You can text us on 22422. After all this, Willis, I'll start with you. We've had Jubilee, of course, led by President Kenyatta and William Ruto, saying the election will go on as scheduled on the 26th of October. IEBC, of course, have said they will give a way forward, and we're waiting for them to talk. First, what do you make of that?
The point is very simple. We are where we are because of the decision of the Supreme Court of 2013. And remember, that's the decision that affirmed the election of Uhuru Kenyatta and William Ruto as president and deputy president. What was good then must be good today. That decision having been good then, it is equally still good today. What is good for the gander is good for the goose. So we are saying, if the Supreme Court did say that Uhuru Kenyatta was validly elected as president in 2013, the same Supreme Court in its own judgment did discuss and interpret Articles 138 of the Constitution and Article 140 of the Constitution, and addressed itself to scenarios of what should happen if any of the, number one, on who should be a candidate in a fresh election after nullifying the election.
And we have that, I believe.
And then they proceed to say, what happens if any of those two candidates, if any of them were to die, God forbid, or any of them were to abandon the electoral quest? A fresh nomination process must continue.
Do we have those graphics? Right, let's look at what he's talking about. That is Supreme Court judgment of 2013, paragraph 291 and paragraph 290, because I took the liberty of looking at some of these laws that have been, both sides have been looking at, I've been talking about for the sake of our viewers. You're talking about this specific one, and this is actually what Ekuru Court has gone to challenge in court. Right, Supreme Court judgment 2013, paragraph 291. If the petitioner was only one of the candidates and who had taken the second position in the vote tally to the president-elect, then the fresh election will in law be confined to the petitioner and the president-elect. That is what IEBC used to declare, to say that it's only Uhuru Kenyatta and Raila Odinga who will vie in the October 26th presidential election.
Yes.
You've gone ahead now, you're talking about paragraph 290, and we can look at that again, which says, among other things, suppose, however, that the candidate or candidates who took part in the original election dies or abandons the electoral quest, then the provisions of Article 138B become applicable with fresh nominations ensuing.
Yes.
And this is what you're talking about.
Exactly.
Gladys Sholei, what do you make of that?
Okay, first of all, I think we need to correct this. You must remember that the 2013 decision by the court was an obiter, and therefore it only has persuasive value. But nevertheless, it was cured by Regulation 52, which sets out the rule. That's an amendment that was made in 2017, yes, which clearly states that when the time frame within which must withdraw. So this current the word abandonment was introduced by the Supreme Court. It is not anchored anywhere in the Constitution, neither is it anchored in our legislation. It was a new word made by the Constitution. Hence the reason why in 2017, when during the passing of the regulations, Regulation 52 was put there to cure that particular problem.
Okay, and we can look at that as well. Election regulations, for the sake of our viewers again. No, this is the Constitution. We'll look at this later, Article 138. Election regulations, talking about you can, and when we look at 2, it says where there are only 2 nominated candidates and 1 candidate withdraws, the remaining candidates shall be declared duly elected in accordance with Regulation 53. This is what you're talking about, and the provisions as to how one can withdraw.
Well, first of all, it is clear what that regulation talks about. It talks about withdrawal after a nomination. In the case of a nullification of an election, yeah, where there has been no nomination of candidates, this particular regulation does not apply. Number 2, if you want to know that Jubilee are fully aware that that regulation does not apply in this particular instance, you look at the proposals in the draft amendment bill to the election laws, where they have introduced a special section, I think it is 86A, where they specifically seek to codify the words of the Supreme Court in 2013 into law. And that particular new section that they want to introduce in the electoral laws says specifically that to cure this particular lacuna, they have put it in law specifically that in the event one candidate after a nullification pulls out, exactly, and they know, I mean, everybody was aware that there was that gap, and that is the reason why
is that the reason, and we can look at that as well.
So you cannot fall back to the regulation talking about withdrawal after nomination, because that doesn't apply in this particular instance.
Okay, if you remember at the time of the nullification of the judgment of the Supreme Court, James Orengo clearly said there shall be no election. He said that on the steps of the Supreme Court. And once he said that, we anticipated that they will try and abandon using that 2013 decision. Hence the reason why the proposed amendments.
Well, this is what that proposed amendment said. I'll come to that just for the sake of our viewers again. That is the proposed amendment on the Elections Act. Is a new provision, Section 86, I think 4B, where only one candidate remains after the withdrawal. The remaining candidate shall be declared elected forthwith as the president-elect without any election being held. And it actually also says that for you to withdraw, you must write a notice to the IEBC. But so does that come into effect?
Okay, I think those amendments. And I think Hussein, it's good for us not to mislead Kenyans. First of all, the withdrawal by Raila Odinga is not anchored in law. It's neither anchored in the Constitution, neither is it anchored under. Neither is it an abandonment, or a withdrawal under Regulation 52. So therefore, it has no legal effect actually. And there are three scenarios that can happen. One. And I think we are depending on IEBC and the Supreme Court to decide what they're going to say going forward. Let's wait for Justice Motivo's decision tomorrow. Secondly, also, it could be that IEBC may fall back on the precedent that they set in declaring the Kikuyu MP duly elected because he was unopposed, or it could be that we go forward because he is not withdrawing. The withdrawal is post the nomination deadline, deadline, which means
that is very wrong. Nominations for candidates participating in the fresh presidential elections.
All right.
So which nominations is somebody going to withdraw from 3 days from the nominations? There are no nominations. And then he goes further to say, pursuant to the decision of the Supreme Court in petition number 5 of 2013, Raila Odinga versus IEBC and others, interpreting the provisions of Article 143 of the Constitution on fresh elections, the fresh presidential election shall be contested between the following candidates. So we are anchoring these fresh elections on the decision of the Supreme Court, interpreting a constitutional provision.
And I think let's do this. There's no need to keep quoting the law on this, because the decision that has been made is a political one. Abandonment is not anchored in law. It's political. We know very well that Raila Odinga had no intention of going to the elections at all. It's unfair that he had people nominate him. He collected money on behalf from the members of the public saying that he's running to an election, and then he ends up abandoning. And I think it's unfair to the people of Kenya.
Reasons why,
and in a way, I'm glad that he has actually withdrawn, because it's good for Kenya. We can end this very protracted electioneering process.
There are reasons.
Okay. And we can finally go back to our lives.
I'll let Charles speak now. Charles,
thank you very much, Hussein. And I think we are in danger of losing the question that you asked. You asked, are we going to have an election on the 26th of October? For me, reading the Constitution and specifically Article 143, it's actually not debatable. The Constitution is very clear. Once the Supreme Court made its decision to nullify the election of Uhuru Kenyatta, then the Supreme Court didn't even need to tell us there will be an election in 60 days, because that is provided for in the Constitution. So the one thing that we cannot be discussing is whether there will be an election on the 26th of October, because the Constitution is very clear. It doesn't provide an alternative. So I think what we should be discussing
who will the election be between?
Who the election will, yes.
Will it be with Uhuru Kenyatta and Raila Odinga?
We have not said that. We've said they must abide by that decision in 2013.
Willis, I was answering the question he asked.
Yeah, one of the points that we need to make, my brother, Mohammed, you know, people need to understand the history, how we came about to be in this particular situation. It is not correct for you to come and lay blanket statements and say Raila Odinga never intended to go into the election. In fact, I was there on the steps of the Supreme Court when the statement that my senior Madam Shulei is alleging was made. It was made that we are not going to have elections without the necessary reforms going into an election. And you see, one of the things that I don't understand about our brothers and sisters on the Jubilee side, if the Supreme Court said that there was absolutely no blame that was going to be laid on their candidate Uhuru Kenyatta, and that all fault was going to fall on the IEBC, and they gallivant around the country crying that their victory was stolen, yet the person who is responsible for taking away that victory has been identified by the Supreme Court, but they do not want to participate in a meaningful discussion of getting to a place where we can have people of integrity to oversee the election, so that next time, should Uhuru Kenyatta, God forbid, be declared president again, then there is nobody to blame. That victory is clean and it will stand. It would seem to any reasonable person that if you have been derived of a benefit or something because of the fault of another, you would spend your entire energies and time on making sure that it does not happen again. So we go forward and lay forth a plan to make sure that at least we can have a credible election. We set down some minimum reforms, and I have actually distilled those requirements to only 2. That we get fresh suppliers, because there are questions about the people who supplied the technology and the people who supplied the ballot material. Number 2, that the people who are responsible for you know, messing up and bungling the election. And they say, how do you settle on these people? Yeah. A very simple exercise, for instance, even as we speak today, Hussein, the court order by the Supreme Court remains undischarged. And you know, a court order does not go away. It's not a cloud that it will be blown away. The court order requiring that we get access to the database, and I was there myself, it has not been complied to today. So you have an ICT manager sitting there, lying to us that he's going to grant us access 4:45 o'clock on the day that the deadline that the court has set. We have not been granted access to the servers. And then he says he's unable to gain control even himself. So who in IEBC are we supposed to point a finger to when a court order directing access to ICT is not complied with? Are we supposed to go after the T-girl? Surely. It is common sense that the ICT manager is responsible. Didn't
my friend Wakili, didn't the Supreme Court take that into account when it gave its final orders?
Yes.
Secondly, you said something which clearly is misleading to the public. The Supreme Court did not identify an individual.
We have identified.
We have identified. Listen, the Supreme Court. Listen, no. The point is this: the Supreme Court did find there were illegalities and there were irregularities. So that when we have illegalities and irregularities,
let's just make his point. Let's just make his point.
Nobody's shouting.
Shouting doesn't help.
Shouting
doesn't help. The point is this: what we are saying is that the Supreme Court gave final orders. Many of us, including myself, did not agree with the Supreme Court, but we have no choice. It's not a question of agreement. We are bound by it. So let's be bound by what the Supreme Court said. You cannot walk out and say, yes, we have a judgment, and then you say, now, behind that judgment, we are going further to identify individuals.
So because you're saying the Supreme Court did not did not find anybody culpable.
In fact, it specifically said that it is unable to find fingerprints of any.
So why don't you let for NASA then? Why don't you let the investigations take its course?
Let me explain to you. Let me explain to you. The point is this: the Supreme Court did find there were irregularities and illegalities.
By
now
who?
remember. What was before the Supreme Court were the pleadings that parties had brought before them. The Supreme Court was not acting as a criminal court. But the court, based on the evidence before it, finds there are illegalities and irregularities. We as a coalition have gone behind to inquire who is responsible for some of these irregularities and illegalities. And I can distill for you, sir. Some of the illegalities is that there was use of illegal documents to declare results in certain constituencies.
Yes.
The person who allowed those illegal documents to get into the system has committed an illegality, and we have named them.
You know,
the person, let me finish, you said let me finish. The person who decided to use forms that didn't have serial numbers has committed an irregularity.
Okay.
And we've named that person. So that when we say that these persons who are responsible for the nullification of their victory,
according to you, then, is it enough for you to name that person and that person should now...
We are saying as long as you've been adversely mentioned and your involvement in a process has been overturned. I'm coming to that. We have adversely mentioned you. And for us to adversely mention you, the Supreme Court has found you are responsible for a particular process.
You being
and
who?
the court, I'm finishing, the Supreme Court has found your process was wanting, and the Supreme Court has condemned your process. The Supreme Court condemns the the ICT process. The person in charge of ICT is known. We don't have to get NASA to name that person.
The one thing the four of us have is, first and foremost, we are lawyers. Before Gladys and I are Jubilee leaning, and my other two colleagues are NASA leaning.
We are constitution leaning.
First, no. You see, that is the problem.
We are constitution leaning.
That is you are not constitution leaning.
You should allow me to
I think Sifuna.
It is me.
I know how I self-identify.
It is me who is describing you.
On me.
Okay, Charles, just make your point. Charles, make your point.
My point is this. Let us be faithful to the law. And the law here is the process is very clear. They went to court, the petitioners. The respondents responded and resisted. The Supreme Court found in favor of the petitioners.
On what basis?
So let's
talk about irregularities. Let him finish. Just let him finish, Willis.
Yes.
Let's make a point, yeah.
Yes. Irregularities
and illegalities
committed by who?
But the court itself was very clear in what it declined.
Charles, the court was not a criminal court.
Yes.
That's for sure, isn't it? There are investigations that have been launched. Are you saying we go back to a fresh election with the same IEBC that committed illegalities and irregularities without anything being changed?
Hussein, if we say, so are we saying that if the investigative arms are going to take a year to do that in the meantime we have to wait?
So the president himself has asked people to step aside when they are being investigated.
Hussein, who is asking people to step aside? Because the same Supreme Court said to IEBC, you IEBC, we have nullified this election because of irregularities and illegalities, but you IEBC, go back. You IEBC.
Yes.
Commission, isn't it?
Yes, the commission as a body corporate.
Not necessarily.
Not the individuals. Not the individuals.
But okay, just let's wind up on this. But Charles, my question was.
Yes, ask your question.
This is the investigative body. The DPP has launched investigations.
Yes.
Are you saying, Charles?
Yes.
Regardless of how these investigations go, a commissioner is being investigated. A manager of a certain in IBC, any manager is being investigated. You're saying they should go on and do this election, regardless of what happened?
I think what you must realize is that there's been no wrongdoing found on those officials. Yeah. And remember, those officials also have rights. And it is very sad that this is coming from one Raila Odinga who fought for people's rights and fought for this current constitution, which we respect him very much for. You would expect him to be the one person to protect those rights. If he wants his rights protected, and he went to the Supreme Court and he got a nullification of the election, we have respected that nullification. We have said, let us go to the election. But again, also, those same young people in IEBC also have rights. There is a process for removal of those people from office. It cannot be that people will be removed from office over years and years in this country because Raila said so.
If they're found,
or because my friend Sifuna here said so. It's unfair. Yes, if they are found culpable, they shall leave.
What's the problem with that?
I think we are absolutely losing the point here. One of the things that is very clear in my mind is that the IEBC has been claiming that some of those reforms that we have proposed require time for us to be able to achieve them. We have provided the time by withdrawing our candidature in accordance with, when my senior talks about respecting the Supreme Court decision, we are going by the Supreme Court decision, and it is the IEBC that brought this particular election on the 26th within the ambit of the decision in 2013, yes, which Willis has referred to in their Gazette notice. So what is supposed to happen is very simple. We have withdrawn our candidature. The Supreme Court said that the effect of an abandonment at this particular stage in these special circumstances of an election that had been annulled is the same as if somebody has died under Article 138, sub-article 8.
Yes.
So what we do right now, the Constitution is clear that this election is supposed to be cancelled.
There is no place.
So that we go back.
Where in the Constitution is the word abandoned? Where is the word abandoned?
Where is the
I want
so
Sifuna.
you have asked a question, let me respond.
Okay, but I also want
Sifuna,
Sifuna, what you're not telling people, let's look at the ranking of law. The Constitution is supreme, followed by acts of parliament, then followed by decisions of the courts, which is one of these is the Supreme Court decision. So the question, hold on. So in this one, this word introduced by the Supreme Court about the word abandoned does not exist in the Constitution. Sifuna, I want you to check the law. I taught you the law.
Okay,
there is nothing called abandoned.
Let me respond.
Abandoned is not envisaged in the Constitution whatsoever.
Agreed.
It only envisages the death of a candidate.
Agreed.
Unless your principal is planning to commit suicide or contemplating suicide, I don't see how that can apply.
And of course, what we are talking about now,
so
for the sake of the viewer, is the Supreme Court judgment 2013, that is paragraph 290. Yes.
So the question has been posed.
It was an obiter.
You have given the hierarchy of laws, and you have put the laws that are developed by the judges at the bottom, which I agree with you. But that ranking cannot apply where there is no specific law to rank with the decision of the court.
There is a regulation of an act of parliament.
Just a minute. Let me answer the question. The ranking, you cannot rank laws that are non-existent. This particular situation is a situation that had not been contemplated, and it is in fact the Attorney General himself who sought that clarification in 2013, and he obtained the clarification.
Obiter.
So that
Obiter.
Just let him finish.
The clarification
it was obiter.
It was obtained nonetheless.
But wasn't it obiter?
Just let him finish. Let him finish. Let him make his point first.
And it only has persuasive value.
Let me finish. That same argument, because I have said, and Willis has pointed out, the Gazette notice, it is the IEBC relying on that same decision that you want.
Let me ask you, did you discover the Gazette notice this week?
Let me finish.
Just okay, guys, let's have a civil conversation.
Did they find the Gazette notice yesterday, today?
Have you seen the... And I finished my point.
Finish your point.
They stumbled upon the Gazette notice
today. It is
today.
very simple logic that the Commission read the decision of 2013. I think they relied on paragraph 289 of that particular decision. You cannot tell us to stop at paragraph 289 when there's a paragraph 290. So it is the Commission that has brought this particular election, the entire election of 26.
When did you discover the Gazette notice? Today?
No, we didn't discover.
Because you should have abandoned the election the day the Gazette notice came out.
That is why we have given a chronology of events of how we got here. If indeed there was goodwill from the Commission and from the IEBC that we can engage as political players in this country
Sifuna, I've just
and
asked you a
actually
very
agree
simple question
on the minimum reforms that we needed to implement at the IEBC, we would not be in this particular situation today. We are here because we have realized as a coalition that absent of the reforms that we have proposed, very minor things that we should actually be able to agree across the political divide, absent of those reforms, we are now falling back to the decision of the election and saying the IEBC is citing time constraints for us to be able to achieve this.
You're repeating that. What I would like Sifuna to clarify to us, Sifuna has said there are two reasons. He said, one, they have a problem with the Gazette notice. What I'm saying is that
we don't have a problem.
You said
we don't have a problem.
The Gazette notice is the one that brought us under the ambit of the decision.
So why didn't you withdraw the moment it came out?
It is upon us to decide when we are withdrawing.
Because by the time we were withdrawing, our conditions had not been met towards achieving an election.
Let me say something. Let me say something you're saying. You see, what I find dishonest about my two colleagues here is that in 2013, when the Supreme Court in petition number 5 of 2013 gave its judgment, Gladys Sholei was the registrar of the Supreme Court of Kenya, or the chief of the judiciary at that time. She was part of the process that was litigating. She was in charge of the scrutiny exercise that was directed by the court. She was part of the judiciary. She was a judicial officer. The decision of the Supreme Court was made. Gladys Sholei was at Kasarani, overseeing the swearing in of Uhuru Kenyatta on the strength of the judgment of the Supreme Court of Kenya in petition number 5 of 2013.
And even now we are campaigning on the strength
that
we've been sent back to elections by the same Supreme Court.
Gladys Sholei, from the year 2013 until today, has never found a single problem with the decision made by the Supreme Court in petition number 5 of 2013. Until today, when Raila Odinga decides to invoke that very decision, which was meant to cause him harm, He invokes it. But then today it seems to favor the conversation that Raila is bringing the country into. Gladys Sholei all of a sudden has a problem with it.
Okay,
have a problem with it because, let me just finish.
Yeah.
Has a problem with it because the same decision has said if you want to interpret and you want to apply Articles 138 and Article 140 of the Constitution, this is what you are supposed to do. I will oblige my colleagues if they were to say we have a problem holistically with the decision in 2013, including the declaration of Uhuru Kenyatta as president. Then we will say there's a problem, Raila Odinga withdrawing from this election.
If you've never listened to me before, I've always had an issue with that introduction of the word abandon. And I'm quote, you can quote me in public, I did say it, that was a new introduction completely that we didn't know where it came from. And
the Attorney General asked for it. The Attorney General asked for it and it was given.
Hussein, my friend has described me as dishonest, but I'll leave that for another day.
We let them do that.
What I want to ask, and then we can determine who is being dishonest. Two questions. Every lawyer who's watching us now knew in their first year in law school the difference between what the court states that forms part of what we in law we call the ratio of the decision and what is said obiter. My two colleagues here have refused to acknowledge or otherwise whether what was said by the Supreme Court in Raila 2013 on the question that they are referring to, whether it was said obiter or it wasn't. Because it wasn't part of the decision. That is a fact.
Is that a fact?
It was
not a fact. It was requested.
But it was.
There was a party who applied for
it. Let him finish.
Okay, finish.
First of all,
I want to answer you.
The Attorney General wasn't even a party, and
an amicus is a party.
Let him finish. Let him finish.
Amicus is not a party.
He's a party. He's admitted. He's a party. Right of address.
That is why he's called amicus. Anyway, the point is this: that was not an issue that was canvassed before the court. And I am asking them to say in front of the 5,000 lawyers out there whether that was obiter or it was.
Let me answer.
Secondly, so that you can answer both.
Okay.
I would like one of them or both of them to tell us how is it that they propose to get around the very specific provisions of the Constitution in Article 140, Sub-Article 3.
Let me respond.
That there shall be an election where the Supreme Court annuls the presidential election, there shall be an election within 60 days.
The answer is very simple. Was that an obiter or a ratio? The Supreme Court of Kenya was invited by none other than the Attorney General to interpret and to give meaning to Articles 138 and Article 140. The Supreme Court of Kenya has an interpretative jurisdiction.
Which was not invoked.
I'm finishing. Let me finish.
It wasn't invoked.
That was the invitation. That was the invitation which the Attorney General was requesting the Supreme Court to invoke.
No.
And the Supreme Court, let me finish.
Yeah, but when you're
let me finish. I'm not. You asked me. Let me finish.
Just let me.
So the moment the Supreme Court was invited by a party to the proceedings, and in the amicus brief by the Attorney General, this question was there. It was open to any party to make submissions on it. It was part of the proceedings before the Supreme Court in petition number 5 of 2013. And the Supreme Court proceeded to interpret. To interpret means to give meaning to the provisions of Article 138 and Article 140. The meaning was given to mean that if we have a fresh election, the candidates shall be the following: 1, 2. And they proceed further to say, what happens if there's a withdrawal or there's death? This shall happen. So that was not an obiter, as my friends want us to believe. That was a decision of the Supreme Court interpreting a live issue that they were invited to do.
Okay, right. So tomorrow, the High Court will deliver, now it has become a very key judgment on this issue of Ekuru Court, who sought to be included in the fresh poll, that is after IBC confined it to Odinga and Uhuru Kenyatta, based again on that Supreme Court judgment of 2013.
Yes.
So what impact do you think the judgment will have if, for instance, Ekuru or Court is not included? Gladys Sholei.
The danger you ask is you're going to discuss, and I'm just wanting to mention this, that this is a live matter before the courts, and we must be very careful on the sub judice rule if we start entering ourselves specifically when you ask the question directly.
No, I think we know about the sub judice. As long as we don't discuss the merits and demerits of the case, then we are safe. But I think one thing is clear. We have a few things we are watching coming forward. One, first of all, we have a situation where the candidate has withdrawn, and I think it's very good for us, so then this country can move on, because we are tired of electioneering. We want to go back and build our economy. So this is a good sign. It's going to bring a close to this. Number two, Jubilee is ready, and you can see them campaigning all over the country. They are ready to go to the election. And then the second thing is that let's watch and see what the decision of Justice Matiba will be tomorrow. And also we are waiting out to see what the decision of IEBC will be. And also whether IEBC will want to go to the Supreme Court for an interpretation, or do they want to make the decision. We'll be watching, because it is in their hands. It's not when NASA says so or when Jubilee says so. Yes, but we are ready to go to the election. And I think it's unfortunate because one political party does not want to go to the election. They set that up from the beginning, and when they realized that the proposed amendments were actually going to impact on their plan, then they decided to withdraw just on the day that the
so what happens? What happens after the decision of IEBC?
Personally,
if they are to say the election is going to be held on October 26th.
Personally, I expect nothing but an announcement from the chair of the IEBC in compliance with Article 138, Sub-Article 8, of the cancellation of that whatever election he had planned on the 26th. And by the way, the ruling of the High Court, or the judgment of the High Court in the Kuru case, would now have no implication.
You don't think there will be an implication on that?
Absolutely, because I doubt that you can use that decision of the High Court to resuscitate an election that is already dead in the water. So what we expect tomorrow is an announcement from the IEBC that they have cancelled the election. They give us a new timetable for nomination of candidates from all political parties, and whoever independent is expected or is interested in running for the election. And we have an election. Now, one of the things that we have to make very clear from a political side is that when you see our brothers and sisters in Jubilee upset, you know, when we were playing soccer in primary school, people used to like to have opponents who have some levels of incapacity, where the playing field is not level. So you feel happy just punching somebody whose hands are tied behind his back, and then you call yourself a champion in boxing. So they are so upset that we have pulled the rug under their feet, that we know that whatever election was going to be organized on the 26th was not going to be a fair election. So we are ready for them. We are ready for the repeat election. We have not pulled out of elections entirely in the history of the country. We know that
one.
Absolutely for this specific.
So what if tomorrow IEBC release? What is your next course of action if IEBC insists the election will go on? If they say the election will go on,
IEBC can make a decision on its own, but we are a coalition that is very faithful to the law, and we respect decisions of the courts as and when they are made, even when they are not favorable to us. So IEBC can do whatever sham they want to do. If they don't want to respect the decision of the court, that is their problem. They are known, for example, for not respecting decisions of the Supreme Court.
Absolutely.
They are even in contempt as we speak right now. So if they made that decision, I'll not be surprised. I'll simply say it's still part of the same, what they've been up to. And that even will be telling you that our request for the irreducible minimums were ignored just the same way they ignored the Supreme Court when they were ordered to give access to the servers. So I will not be surprised.
That means legal redress for you again.
Absolutely.
You see, it will not. You see, for us, we stand on the side of the law, and it's good. My learned colleague Sifuna said it, that we should be associated with fidelity to the law, as we believe in the law.
Gladys Sholei, Honorable Sholei. So what happens if IEBC decides for Jubilee, because you're saying the election will go on, if IEBC decides, as NASA believes, that there'll be no election now on October 26th? For Jubilee, what do you do?
No, I think what's happening is we are in a situation here where we are not sure today, but in the coming days we will be sure what's going to happen, because we are not without options. The Constitution is very clear. I think what's happening at the moment, our Constitution is being tested. We are trying to see how stretched it can be, and I think there is alternatives. So it will depend on which, like I told you, IEBC could decide that they will declare the Uhuru Kenyatta duly elected, or they could decide that they go ahead with the election even if Raila Odinga has abandoned. They could decide. It could be that the decision tomorrow will say that Ekuru Aukot should be back on the ballot. So yes, it's a bit uncertain now, but only today, but they are answers. Our constitution is large and sufficient enough for us to be able to follow. As Jubilee, yes, we were disappointed at the decision, but then we have gone out to campaign, tried to reach out to Kenyans humbly again, asking for votes, and we are ready to go to the election. At no time have we said, I will only go to the election if so-and-so is removed from office, if this so-and-so is put back in office, or if this printer is removed. I think, and this is not just something that NASA has said now. NASA has been putting conditionalities all the time. As far back as when they said we don't want Hamed Isaac team, and those were, they went home. And then now they came back and they said, okay, we have this IEBC. And in a short while, they said, we don't like so-and-so. It has become, it's almost like whenever we give, they get what they want, they create a new conditionality. And I think there is no time that they can't have their way all the time. And this country has to move forward. And you know what? If IEBC, we are, in fact, the people who are law-abiding, is Jubilee. Because think about it. Think about it. And I know they like, they shout, they make fun and whatever. Remember, you're the ones who put people on the streets. People have gotten injured.
The law.
No, we didn't. No, hold on. Hold on. Yes, exactly. Yes, but you see, you have a right to picket. But when you go and picket, remember, if you are armed, or if it's not peaceful, then your rights end.
We don't carry any
when
arms.
You bludgeon on a kid in a slum in Kisumu, can you claim you are
let me finish saying, and I think, so what we should say is that for all this time, I think what is sad is that you have put people through demonstrations. You have made IEBC reorganize the election management team. You have made IEBC sit down and reorganize the election plans. You have made the entire country and spent 20 billion shillings of Kenya's money to prepare for the election. Then suddenly you abandon. In fact, I'm sorry for your supporters. I feel sorry for them. I would feel sad if I was supporting someone who doesn't care about my support and just abandons.
I think our supporters can speak for themselves.
Okay, Charles is going to speak now. And finally, for all of you, I mean, we saw some texts, somebody saying, is there still time, and maybe the two sides should still talk. Do you think there's still time for that? Is still something can still be salvaged from where we are right now?
You know, Hussein, this country went to a lot of trouble, and many of the people on what is now both sides of the political divide went to a lot of trouble for us to have the constitution that we have today. And this constitution has the answers. To answer your question about IEBC, I will be shocked if IEBC tomorrow were to say anything other than that they are bound by what the Supreme Court said and what Article 140 of the Constitution says, and that the date they have given us, we will have an election on the 26th. I would be shocked if they said otherwise. I think one of the major problems here is, and I think this has been evident in the discussion we've been having, my friends from NASA, they seem to take the view that it is only when they say it that it becomes constitutional. That's why they are able to walk out of the Supreme Court with a judgment in their favor and then add to that judgment things which were not said by the Supreme Court and make that the point of determination on whether the country is moving forward or not. And that is what is sad. And to do that and then at the same time claim that you respect the Constitution, I think is not fair to the country.
Okay. Let me say this. Charles Nyachae was the one in charge of overseeing the implementation of the Constitution of Kenya from the year 2010 up to, I think, sometimes 2 or 3 years ago. I'm not sure what the exact time. And part of his mandate required to ensure that there's faithful implementation of the Constitution. Article 138 and Article 140 of the Constitution, which he keeps mentioning, have been interpreted by the Supreme Court of the Republic of Kenya.
They have not.
In petition number 5 of 2013. When I said he's being dishonest, you can imagine he had the ultimate responsibility to oversee the implementation of the Constitution. If that statement was not proper, Charles Nyachae had a platform through his commission to go back to court and seek an advisory opinion. But as we speak right now, it is only today, since I knew him, it is only today that I've heard Charles Nyachae raise a problem with any part of the decision of the Supreme Court of Kenya in 2013. But let me say this.
I am not raising a problem.
There was a question which you asked. You said, there's something you said.
I have not raised a problem with what the Supreme Court said in Raila 2013. I have simply said the statement that they have drawn out. And I was saying, the first lawyer you bump into when you live here, ask them the difference between obiter and the
ratio decidendi.
And the ratio decidendi of a case. And they know it. I have not said there was anything wrong with what the court said.
So if everything was right with Raila 2013, then let us implement Raila 2013 as it is.
What is
because it is the law as it was in 2013, it is still the law as of today. Unless anybody goes back to the same Supreme Court to vacate that decision.
An obiter statement can never be the law.
Let me just finish it up by statement.
Every first year law student knows.
You had asked a question about if there's an opportunity
to salvage this.
Let me say this. One thing that we must all appreciate as a country is that election is like a football match. All teams must agree on the ground rules. Even if they can't agree on those ground rules, they may even decide that let's play home and away matches. Elections are done in a very peaceful, in a very harmonious environment where every player is given an equal opportunity to contest. But what we have right now in Kenya, I heard my sister say, and to her credit, Jubilee has not made even a single request to IEBC. Do you know why? Because Jubilee is IEBC and IEBC is Jubilee. All that Jubilee wants, IEBC will do for them.
But they have some changes to amendments.
Let me finish. But for NASA, we have to constantly keep begging and begging and demonstrating before you even get a scintilla of commitment from that same commission. But if we are being honest to each other as a country, we must agree on a level playing field, all players to agree on the rules, then we go to elections.
Okay.
And these, let me just finish it, Hussein. And what I'm saying, these are not my own views. These are views that are found in Article 81 of the Constitution on the principles that should guide the electoral system. It must be transparent, it must be accountable, it must be free and fair, it must be free of violence, it must be free of intimidation. In other words, the Constitution already says what should be a guiding framework to negotiate.
All of which Jubilee agrees with.
Okay, Gladys.
I think whichever way, we are going to find a solution to this. And either we will have this election and we are ready to go forward with it and abide by whatever decision IEBC makes. And I think what is clear for us is that we have to go to an election. NASA does not want to go to an election. It is unfair that they actually took us this far, got the country to spend a lot of money, in fact collected money from members of the public, and I hope you shall return it, Sifuna. Make sure you return all the money to the members of the public, since you have abandoned your quest for the presidential seat.
You know, my sisters and brothers in Jubilee have an eye for the petty. First of all, I can guarantee you that none of the people sitting on this desk, other than myself and Willis, have contributed money to the causes of NASA. I personally gave money to that pay bill number, and I know where that money has been spent. None, if any person who sent the money to the pay bill, because we can get a statement from Safaricom, if anyone wants that refund, Edwin Sifuna is guaranteeing you will receive that refund. If you paid the money and you want it back because you think there's nothing it has done. Number two, you asked a very important question on whether there is opportunity for these people or the leadership of this country to speak. Actually, Raila Odinga has always been ready to have discussions with the leadership of Jubilee on having a level playing field for the election. And he has been repeatedly frustrated. You will remember, under the auspices of the IEBC, several meetings have been called. The latest one, in fact, at Bomas, and Raila Odinga showed up, and Uhuru Kenyatta, of course, gave it a wide berth. And you saw his surrogate saying, the president is too big to go to Chebukati. If you have to meet him, you have to go to State House. Because you see, for him, everything is a pissing contest to show who's boss. At the end of the day, this country needs leadership, and if the leadership is not going to come from the presidency, then we don't want to engage. Lastly, Hussein, I don't know what the whole law is, because the law for us is very clear. This has been one of the most difficult legal decisions that the NASA team has ever had to make. Every lawyer in NASA was actually consulted, and I dare anyone say he wasn't, on this particular decision because it was one of the most difficult legal questions to do. But what we have succeeded in doing is giving IEBC and the country an opportunity to actually, have the time that is required for them to put the electoral, field in order so that we can actually have an election. I can guarantee you that nobody enjoys this temporary incumbency by Uhuru. And in fact, the next argument we want to raise is whether indeed, when the Constitution talks about temporary incumbency, it means a period that spills over 90 days. We want him to vacate that office.
Okay, you're going to open up another major discussion right now, but we are completely out of time. But now, just because you mentioned that, I'll have to let Charles respond to that specific part.
I mean, it was something that
it has to be responded to.
But they also had a chance to be able to make the electoral laws and get that level playing field during the Kiraitu Orengo-led select committee.
Okay, Charles, if you can respond to that.
No. I think my friends, I want them to remember that first and foremost they're lawyers before anything else. And I mean, if you're talking about the temporary incumbency, the Constitution is very, very clear on one thing. Until the day that the president either is being, which is what some of us expect, that he is being sworn in for his second term, or, working constitutionally, he is handing over to another president until that day. He continues to be president. It's here in the Constitution.
Even in 2017.
Let me just say this, Hussein.
I told you you're opening up.
That is what temporary. We will have a discussion
now.
I don't know.
Temporary is
not permanent.
Temporary means the days between when the term for which he was elected
from the time of the election up to the time of the swearing in of the next president.
That is the time of the election.
Let me just say this. I like it that my two colleagues here are comfortable that Uhuru will still be president forever. So if listen, if that be the case, then we have no crisis. Everything is okay. Let us deal with these questions of electoral reforms. No, let me finish, please. When you talk, let me just finish. No, just let me finish. It is my time, my friend. No, let me finish.
Who said Uhuru is going to be president forever?
Let me finish, but you interpreted it. I gave you time.
Let him not patronize us.
Let's be civil. Just let him respond. Okay, finish.
I think they are used to patronizing everybody and getting away with it.
You are saying there will be no issue because the president will continue in office. And I'm saying it is okay. Let us now, that it means we have enough time to deal with our issues of electoral reforms. Between now and then. So why can't we just take time and deal with all these issues of electoral reforms and then move forward as a country?
That now is what is petty. Because
but it's not saying this.
No, we have to leave it there.
It was his argument.
That wasn't my argument.
It was his argument.
This discussion will obviously have to go on for days to come. But thank you so much for making time for us tonight. Honorable Shulei, a lawyer and also woman rep was in Gisha County. Lawyer Edwin Sifuna, Charles Nyachae, and Willis Otieno, thank you so much for making time for us tonight. Keep talking to us. The hashtag is a big question on Twitter. You can text us on 22422. I'll be back with a final look at your feedback.
Get 30 or 50 GB to share with your co-workers or customers via a hotspot or wireless router. With easy data bundles, the Kenya School of Integrated Medicine is a ready institution.
Dad, I need to tell you something. Mommy is working with the grandfather of Emiliano.
Who did you just speak to on the phone? Nani hawezi penda nguo zake zikinukia hivi?
New Whitewash Extra Bar Soap. Kila kitu ni extra. Extra lather and a lot more extra strength for that extra clean wash. Bidhaa bora kutoka Pwani Oil Products Limited.
Okay, mimi naitwa Christopher Joroge Jogona kutoka jiji la Kiambu, Kiambaa, na mimi mfanyi biashara. Sasa hii pesa nimeshaishinda, nitapanua biashara yangu na zile zingine nianzize miradi baribari. Watu wa Kiambaa ni wangewahisi waanze, wale hawajaanza kucheza, wacheze sabiki na wajue watashinda. Mimi ni shabiki. Je, wewe?
Hata wewe pia waweza kuwa mmoja wao. Tuma neno join kwa 29063 uwe shabiki.
Shabiki.com